I'd like to take this opportunity to introduce today's presenter, Jennifer Damon, Director of Compliance and Chief Privacy Officer at AccuSource. Jennifer graduated from the University of Akron School of Law with a Doctor of Law degree and has over 10 years of experience in the background screening industry. She is an experienced compliance professional with knowledge from both the employer and consumer reporting agency sides. She has performed various roles in the industry, including interpretation of criminal and civil record summaries, managing quality control, and managing the E-Verify program, including audits for a billion-dollar facility services company. She has experience with government clearances and contract review. Jennifer is responsible for AccuSource's compliance department, including federal, state, local legislation changes, and industry accreditation. Additionally, she oversees the quality assurance process. Now I will turn the presentation over to Jennifer.
Good morning and welcome to our mid-year compliance webinar. We'll be addressing numerous topics today and we'll be answering questions at the end of the presentation. Please send any questions you have and I will address as many of them as possible or will follow up through email if we run out of time. 2021, the one where everything starts to open back up and hiring explodes. It has been a busy year in our industry, and employers face numerous changes that can affect their background and drug screening programs. We will start this presentation by highlighting some of the key updates made so far this year. We will then go over some trends to watch as 2021 comes to a close. Our review of the first half of 2021 will include updates on ban-the-box laws and related legislation, updates on salary history bans, a privacy law update as new states join California in passing comprehensive privacy laws, and more marijuana legalization and court decisions on how employers can and cannot approach marijuana in the workplace. We will then discuss anticipated trends for the rest of 2021 and provide best practice recommendations. As usual, before I begin my presentation, please note the legal disclaimer on your screen. Neither AccuSource nor I am providing legal advice, and this webinar is for informational purposes only. We strongly encourage you to seek the advice of employment law counsel who is knowledgeable in background screening before you make any decisions related to your screening program. Please also keep in mind that this is a general discussion. I will not be covering specific state laws and exemptions. For example, some employers may have exemptions to the general laws due to their industry or the type of position. It's best to discuss your specific business needs with legal counsel to ensure that you are compliant. Our discussion is also limited to criminal records. We will not be discussing credit reports, which are governed by federal law and are also restricted by certain state laws. First, we will discuss fair chance legislation, also known as ban the box. Before I go over new laws, let's first review and refresh what banning the box actually means. These laws prohibit employers from asking about criminal convictions before a certain point in the hiring process, generally before a conditional job offer is made or before an interview is conducted. For example, an employer in a ban-the-box jurisdiction typically cannot include questions about criminal convictions on the initial job application. In other words, they're banned from including a checkbox asking if the applicant has been convicted. The goal of fair chance laws is to allow applicants with prior convictions to not only obtain an interview, but also advance to a certain stage in the hiring process before being asked about prior criminal history. Additionally, these laws may require that the background check process start later. About 75% of the US population is impacted by ban-the-box laws, and they can span a variety of employers, including public, private, or both. In this section of the webinar, I will also cover certain laws that allow ex-offenders to receive certificates or ease liability for employers who wish to hire those with a criminal history. I will also be discussing some new expungement laws. First up, Illinois passed an amendment to its Human Rights Act, which allows ex-offenders to go further in the hiring process. SB 1480 became effective immediately upon its signing on March 23rd. It restricts the use of criminal records when making employment decisions. An employer cannot disqualify an individual based on a conviction until after it has determined that a substantial relationship exists between the conviction and the position, and has engaged in an interactive process with the individual. It is a civil rights violation for an employer to use criminal records to make an employment decision unless one of two exceptions applies. Under the substantial relationship exception, the job position must provide the opportunity for the same or similar offense to occur or involve similar circumstances that existed during the original offense that are likely to reoccur. Employers are required to consider 6 mitigating circumstances. First, the length of time since the conviction. Second, the number of convictions on the individual's record. Third, the nature and severity of the conviction and its relationship to the safety and security of others. 4, the facts or circumstances surrounding the conviction. 5, the age of the individual at the time of the conviction. And last, evidence of rehabilitation efforts. A second exception exists where the hiring or retention of the individual would cause an unreasonable risk to property or the safety of others. The amendment also requires that an interactive assessment take place between the employer and the individual. If an employer plans to take adverse action, it must provide written notice of its preliminary decision. In that notice, it has to identify the specific conviction or convictions that the employer feels meets one of the exceptions that I described on the previous slide. It must also provide a copy of the conviction history report and information regarding that person's right to respond to the notice and to provide mitigating information before the decision becomes final. The employer must wait at least 5 business days between notices and must consider any information provided by the individual before the employer makes a final decision. If the employer decides to take adverse action after all, it must provide another notice explaining the basis for its decision, including the specific conviction or convictions. It must also provide any internal appeal procedures that the employer has, as well as notification of the right to file a charge of discrimination with the Illinois Department of Human Rights. Because SB 1480 became effective immediately when it was signed in March, impacted employers should review and update their procedures immediately if you've not already done so. Louisiana's governor recently signed a ban-the-box law that will impact Louisiana employers beginning August 1st. An employer cannot request or consider an arrest record or charge that did not result in a conviction if it receives that information during a background check. When considering criminal records, an employer should conduct an individualized assessment of whether a criminal record has a direct and adverse relationship with the specific duties of the job that justify denying the applicant the position. The assessment must include a review of the nature and gravity of the offense or conduct, the time that has passed, and the nature of the position sought. Upon written request by the applicant, an employer must make available any background check information used during the hiring process. The city of DeSoto in Texas wants to give applicants a fair chance for employment. The DeSoto City Council passed a ban-the-box ordinance on April 13, 2021, which becomes effective on January 1st, 2022. DeSoto employers who have 15 or more employees cannot ask about criminal history on initial job applications. Certain types of employers are exempt, as listed on the slide, but the City of DeSoto, even though it's technically an exempt type of government agency, they are being required to participate. So they're an exception to the exception. The law only applies to initial applications. Employers can ask about criminal history later in the hiring process. Philadelphia recently expanded its existing Fair Criminal Record Screening standards, with changes effective by April 1st. Bill number 2004-79 expanded coverage to independent contractors, transportation network company drivers, rideshare drivers, and other gig economy workers. It also now includes current employees. While the law already allowed a private right of action, the bill replaced punitive damages with liquidated damages up to $5,000. So it could be pretty costly if you violate this law. The mayor also amended the city's credit screening restrictions, but we will not cover that in this webinar. Just be aware of it though. And if you do run credit and the Philadelphia restrictions apply to you, you should definitely review those with your legal counsel. New York City also expanded its existing ban the box law, the New York City Fair Chance Act. The bill was enacted on January 10, 2021. In order to revoke a conditional offer or take adverse action against an employee based on a pending criminal charge, arrest, or accusation, the employer must first conduct an individualized assessment based on 7 factors, which are similar to those under New York Article 23A. An employer must consider whether the individual was 25 years or younger at the time of the offense, and must consider any information regarding rehabilitation or good conduct. It must go a step further than before and solicit information that will be part of its analysis, such as facts and circumstances surrounding criminal convictions. After the assessment, the employer can withdraw the conditional offer if there is a direct relationship between the underlying conduct and the employment, or if there would be a reasonable risk to property or the safety of the employees, public safety of others. The employer must follow the standard Fair Chance Act process, which I will not review in this presentation, but have discussed before. The bill also updated the Fair Chance Act related to the inquiries that employers can make. Employers can no longer inquire about non-pending arrests or criminal accusations, adjournments and contemplation of dismissal, youthful offender adjudications, or sealed offenses. Additionally, employers cannot inquire about or deny employment based on violations and non-criminal offenses. So offenses that are less than misdemeanors, in other words. This prohibition does not include motor vehicle records, though. The new bill also updates the FCA process related to convictions. Employers must now review the FCA factors and provide notice before taking adverse action for criminal convictions that arise during employment. Because of the significant changes that were made to the Fair Chance Act through the recent bill, impacted employers should definitely review very carefully and engage counsel. Arizona passed a law in April that acts more as a second chance law rather than a standard ban the box law. Effective on August 27, House Bill 2067 allows courts to issue a certificate of second chance for individuals whose judgment of guilt is set aside after a criminal conviction for certain offenses. This certificate will allow individuals to apply for and obtain occupational licenses. It will also provide protections to employers who choose to hire those with the certificates, such as protection from negligent hiring and retention claims. Employers are not required to consider the certificates or hire those who present them. and can also still ask about prior convictions. The amendment also does not redact or remove any part of an individual's criminal record. Kentucky created a similar program under HB 497, which is effective this month. In order to obtain a certificate of employability, an incarcerated individual must complete vocational or educational training requirements and successfully maintain a crime-free record for a designated period of time before release. Exclusions do apply. For example, sex offenders cannot receive the certificates. Employers can request the certificate from a job seeker and verify that it's valid with the Department of Corrections. However, employers are not required to accept an applicant with a criminal record, but if it chooses to do so, it receives protection from negligent hiring lawsuits. SB 288, effective this past January 1st, gives some Georgia ex-offenders the chance to have certain convictions removed from their criminal records after a period of conviction-free years. For misdemeanor offenses, an individual can petition the court if it has been 4 years from sentence completion, no new convictions have occurred in those 4 years, and there are no pending charges. Certain offenses are excluded. SB 288 also includes negligent hiring and retention claim protections for employers who provide second chance hiring, which is similar to the ones that we just discussed. Alabama passed the Redeemer Act, which is effective this month and allows for the expungement of misdemeanor and nonviolent felony convictions. It does not include violent felonies or sexual offenses. It is also open to those who committed more serious offenses but later received a pardon. Those who would like expungement must petition the court, and judges will determine whether to grant the expungement based on factors such as the nature of the offense and how long ago it occurred. We just spent some time going over fair chance laws, and there were quite a few of them this time, but equally as important for HR are salary history bans. A number of jurisdictions have already banned employers from asking about salary histories, at least during some part of the hiring process. The goal of these bans is to address pay equity issues that are due primarily to gender. While you may not be based at a city or state that currently has salary history bans, keep in mind that you may have job applicants who do live in such jurisdictions. You should review with your legal counsel to determine if any salary history questions during the hiring process are appropriate for your specific situation. Numerous states have salary bans, as well as some localities, such as cities and counties. The governor of Connecticut recently signed an amendment to law, updating the state's existing pay equity law. It goes into effect on October 1st of this year. The existing law already provided protections related to salary history. For example, Connecticut employers already could not prohibit employees from discussing wages, require them to sign a waiver that prevented them from discussing wages, or discriminate or retaliate against those who did discuss wages. It also prevents employers from asking about a potential employee's salary history. The amendment includes new protections. Employers cannot fail to or refuse to provide an applicant with wage range information at the earlier of the applicant's request for that information, or before or at the time the applicant is made a compensation offer. The amendment also covers employees and requires employers to provide wage range at the time of hire, when an employee changes roles, or at the employee's first request for that information. The pay equity portion of the original law was also amended. Now, Connecticut employers cannot justify pay disparities if the employee will be performing comparable work on the job. In reviewing, an employer must consider the skill, effort, and responsibility required for the position. If it does determine that differing pay is appropriate, It must be able to show that it is based on a bona fide factor other than sex. Examples of factors that could justify pay differences include education, training, credentials, skill, geographic location, or experience. As AccuSource learns of additional salary history bands and related laws, we will review and share with you. Privacy has been a very hot topic in recent years, and we generally discuss at least one privacy law in each webinar. Virginia has joined California in passing its own comprehensive privacy law. The Virginia Consumer Data Protection Act, or VCDPA, was signed into law on March 2nd, 2021, and will be enforced starting January 1st, 2023. Companies may be covered by the VCDPA if they conduct business in Virginia or target Virginia residents with products or services. Like California, the VCDPA has thresholds for when businesses are covered. It must either control or process the personal data of at least 100,000 consumers during a calendar year, or control or process the personal data of at least 25,000 consumers and derive at least 50% of its gross revenue from personal data sale. The law does not include a revenue threshold requirement, which means that larger organizations can be exempt if they do not fall under one of the two thresholds. Because the definition of consumer excludes a person who is acting in a commercial or employment context, this law excludes employee data. It also only applies if the exchange of data is for monetary consideration. The VCDPA also excludes certain transfers of data from its definition of sale and also exempts 5 categories of entities. There are also 14 categories of exempted data sets, including data regulated by the Fair Credit Reporting Act, the Driver's Privacy Protection Act, and specific employee and job applicant data. The VCDPA includes various rights for Virginia residents and obligations for covered companies, not just limited to employers, but companies. However, because employee and FCRA data is exempted from the VCDPA, we will not dive further into the law at this time. Colorado also passed a privacy law this year, and it overlaps with the California and Virginia laws. The law defines what entities are covered. First, the company must conduct business or produce products or services that are intentionally targeted to Colorado residents. Second, the company must either control or process personal data of more than 100,000 consumers per calendar year, or derive revenue from the sale of the personal data and control or process the personal data of at least 25,000 consumers. The CPA does not apply to personal data governed by the delineated state and federal laws or employment records. The definition of consumer excludes those acting in a commercial or employment context, which means the job applicant and employee data is specifically excluded. Colorado's law seems more like European privacy law than traditional US privacy laws. For example, consent is opt-in and requires a clear affirmative act signifying a consumer's freely given, specific, informed, and unambiguous agreement. The CPA has other similarities to GDPR, but I won't go too much into detail since job applicant and employee data is exempt. The CPA is scheduled to take effect on July 1st, 2023, but a cure period is provided through January 1st, 2025. Because the CPA has similarities to GDPR, we highly recommend that you review as soon as possible to determine if it impacts your organization and begin preparations now. It might seem like you have plenty of time, but depending how much data you have, you may need all the time you can get here. I've joked with colleagues that lately I only write about marijuana for our blogs. And it's true that this year has brought a lot of marijuana legislation and court rulings, which I'll go over in the upcoming slides. How do these updates affect employers when it comes to their drug screening policies? In general, employers can still drug test in many of the jurisdictions that have legalized some form of marijuana use. But it's definitely getting more complex as additional states and localities begin to address marijuana. As you may recall from previous webinars and probably blog posts as well, Montana voters approved recreational marijuana in November 2020 in that election. Its governor recently signed legislation that will protect off-duty use of marijuana starting on January 1st, 2022. Under the amendment to existing law, marijuana is now considered a lawful product. What does this mean for you, the employer? An employer cannot refuse to hire or discriminate against an employee due to his or her legal use of marijuana off premises during non-working hours. An employer is permitted to take action if the off-duty marijuana use affects an individual's ability to perform his or her job or affects the safety of others. They can also take action if the use conflicts with the bona fide occupational qualification, where the employer, as part of a professional services contract, can limit the use of marijuana, or if the employer is a nonprofit that discourages use of marijuana by the general public. They can also take action where the employer believes its actions are permitted under an established substance abuse or alcohol program or policy, professional contract, or collective bargaining agreement. While marijuana use does not get a 100% free pass in Montana, employers may find it difficult to take adverse action for positive marijuana test results due to the new legislation. We discussed in our last compliance webinar that Philadelphia was considering a ban on pre-employment marijuana drug testing. The bill has officially passed, and it goes into effect on January 1st, 2022. Under the new chapter in the Philadelphia Code, employers and other employment-related parties cannot require an applicant to submit to marijuana testing as a condition of employment. There are some exceptions to this ban, though. Certain positions are exempt, including law enforcement, those that require a commercial driver's license, those involving children, medical patients, disabled or other vulnerable parties, and positions where the employee could significantly impact the health or safety of other employees or the public. Another exception could apply if a law requires that the employer drug test applicants due to safety or security concerns, or if a federal contract or financial assistance requires drug testing. Finally, an applicant can be required to take a marijuana drug test if the potential employer is subject to a collective bargaining agreement that specifically addresses that topic. Philadelphia is not the first jurisdiction to restrict marijuana pre-employment drug testing, and it wouldn't be surprising if others join this trend as time goes on. Mississippi voters had approved medical marijuana in the November 2020 election, but the state Supreme Court ruled in May that Initiative 65 is void due to an issue of numbers. Under the law, no more than 1/5 of the total signatures to place an initiative on a ballot can come from any one congressional district, which was broken here. While the court said that it is mathematically impossible to meet the standard, it was required to void Initiative 65. Again, they didn't meet the numbers requirement. At this point, Mississippi medical marijuana can be legalized only in one of two ways. First, through legislation, or second, by amending the broken initiative clause in the Mississippi Constitution. At that time, a new statewide vote would be needed to legalize medical marijuana in the state. In May 2021, Alabama became the 37th state to legalize marijuana for medical purposes. Senate Bill 46, known as the Darren Wesley Otto Hall Compassion Act, became effective on May 17, 2021. It legalized the use of medical marijuana for 16 medical conditions or categories of conditions. Interestingly, the law specifies how medical marijuana can be used. For example, a patient cannot smoke, vape, or consume edibles. However, they are allowed to use capsules, tincture, patches, nebulizer, or oil. The law provides almost no employment protections, and employers have new obligations. Alabama employers can still maintain drug testing and drug-free workplace policies and can take adverse employment action against applicants and employees who use medical marijuana. They can also require employees to notify them if they possess a medical marijuana card. Employers are not required to accommodate medical marijuana use. Alabama does warn potential medical marijuana users of employment risks as part of a consent process. Specifically, certifying physicians must proactively inform patients that their use of marijuana could result in termination of employment. Virginia passed two bills that provide protections for medical marijuana users, both of which became effective on July 1st. Under HB 2312, employers cannot take adverse employment action against employees for their lawful use of medical marijuana. They also cannot refuse to hire an applicant based solely on medicinal marijuana use. However, employers are not required to allow on-duty marijuana use or impairment. HB 1862 specifically provides protections for users of cannabis oil. Employers cannot take adverse action against employees who legally use cannabis oil, generally shown through a valid written certificate from a physician. However, an employer is allowed to act if the employee is impaired at work and is not required to violate federal law or risk federal contracts or funding. I discussed earlier how Mississippi's medical marijuana initiative was voided. Something similar happened in South Dakota, which had voted under Amendment A to legalize recreational marijuana in the November election. However, on February 8th of this year, a South Dakota judge granted summary judgment in favor of law enforcement officers who had sued on behalf of the governor. The court held that the amendment was unconstitutional and void because it violated South Dakota's single subject rule. Under that rule, an amendment can only include one subject. The court held that hemp and cannabis are two separate subjects, and the amendment cannot go into effect as planned because technically they proposed two subjects in the bill, but it was supposed to only be one. So we'll see what happens, another technicality, and as always, we'll keep you posted if something else happens in South Dakota. Connecticut became the 19th state to legalize recreational marijuana when it passed Senate Bill 1201, which became effective this past July 1st. Adults who are 21 and over can possess or consume up to 1.5 ounces of cannabis and can have up to 5 ounces in a locked container at home or in the trunk or locked glove box of a vehicle. Home cultivation will be permitted, starting first with medical marijuana patients and then for recreational users. While recreational marijuana is legal now in Connecticut, retail sales are not expected to begin until next summer. It's also important to know that the law will automatically erase criminal convictions for possession of up to 4 ounces of marijuana. Virginia now allows recreational marijuana use effective as of July 1st. Under HB 2312, adults who are 21 and older can use marijuana, possess up to 1 ounce of marijuana, and grow up to 4 plants at home. Retail sales may lag a bit since Virginia has until July 2024 to establish those sales. Adult users do face some restrictions. While they can possess marijuana in public, they cannot use it in public places. Driving under the influence of marijuana is still illegal for both driver and anyone else who's in the car. As for employers, the law does not provide specific protections. Employers should be aware that the law includes an expungement program where eligible marijuana crimes will be automatically expunged by July 1st, 2026. New York joined the recreational marijuana club, with legal weed becoming effective on March 31st, 2021. Similar to other laws we've looked at, New York legalized the sale and use of recreational marijuana for adults 21 and older. While recreational marijuana is legal now, retail sales likely won't start until next year. The bill also included expansion of the medical marijuana program, including a larger list of medical conditions that qualify for medical marijuana. Before we get into how the law impacts employers, I wanted to mention criminal justice reform and record expungement. The state will implement reduced penalties for possession and sale. Also, the law creates automatic expungement or resentencing for anyone with a previous marijuana conviction that would now be illegal. Continuing on with New York, employers in New York already know that they cannot discriminate against employees for their lawful off-duty activities. Lawful marijuana use is now included. There are exceptions. An employer can take action if required by state or federal law, and can also act if an employee is impaired by marijuana use. Employers are not required to violate federal law or risk losing a federal contract or funding. To an extent, New York employers are permitted to maintain their drug-free workplace programs. However, it can be complicated since an employer cannot discipline an employee for lawful cannabis use before starting work that day, but can take action if the employee is impaired at work. Marijuana testing is permitted, subject to any New York City restrictions, of course, but may not be useful because an employer cannot take adverse employment action based solely on a positive marijuana test. New York employers should review the law carefully, especially because employees can bring a private right of action for discrimination for lawful use or possession. New Mexico's governor signed 2 bills into law in April. The Cannabis Regulation Act, or House Bill 2, allows the use of recreational marijuana by adults 21 and over. The rights of cannabis users varies depending on whether they are in a private setting, such as home, or whether they're in public. I'm not going to go into the details of those differences today, but did want to make you aware of them. The sale of recreational marijuana will begin a year from now in April 2022, and other provisions went into effect on June 29th. New Mexico employers are specifically allowed to maintain drug-free workplaces. An employer can also prohibit or take adverse employment action against an employee who is impaired or possesses intoxicating substances at work. Employers can have zero tolerance programs for employees, but the law does not specifically address applicants. So that's a little bit of a gray area right now. New Mexico's governor also signed a bill that amends the Expungement of Certain Criminal Records Act. Effective on June 29th, it allows the expungement of arrest and conviction records of certain marijuana offenses. It also expunges lesser offenses, treating it as though recreational marijuana had been legal when the offense occurred. Eligible records will be expunged automatically after 2 years has passed from the date of conviction or the date of arrest. For those who were arrested or convicted as a minor, the records will be expunged at the earlier of 2 years from the date of conviction or arrest, or when the minor turns 18 years old. Those currently incarcerated for marijuana offenses may also benefit. New Jersey also legalized recreational marijuana under a law known as CREMA, which was signed on February 2nd. Except for non-employment provisions, the law became effective when it was signed. Employment-related provisions become effective on August 21st of this year, so you have a little bit of time to look into this if you haven't already. Let's start with the non-employment provisions. Recreational cannabis is legalized for adults who are at least 21 years old. New Jersey has also decriminalized some marijuana offenses, including the possession of small amounts of marijuana or hashish, and has removed marijuana from its previous designation as a Schedule I controlled substance. Those with marijuana-related offenses are able to vacate offenses that occurred before the law went into effect. Also be aware that 2 other related bills were passed. A 1897 reforms criminal and civil penalties for marijuana and hashish offenses, including remedies for those currently facing certain marijuana charges. A 5342 focuses on marijuana penalties for individuals younger than 21. CREMA provides protections for applicants and employees. Employers cannot refuse to hire or employ any person solely because that person uses or does not use marijuana for recreational purposes. It also prevents employers from discharging employees who use recreational marijuana. Normally, these types of laws allow exceptions for certain types of positions, including safety-sensitive positions, but CREMA does not. However, that being said, employers can still maintain drug and alcohol-free workplace policies. Employers are permitted to prohibit the use or possession of marijuana or being under the influence at work or during work hours. Federal contractors are allowed to update their policies consistent with federal law. CREMA outlines specific drug testing requirements that an employer must follow in order to take adverse action against an employee who is under the influence at work or during work hours. First, the employer must use scientifically valid methods for testing. So urine, oral fluids, those types of testing. Second, a certified workplace impairment expert must physically evaluate the employee and determine that they are under the influence of marijuana. These restrictions apply to marijuana drug testing at any time, from pre-employment to random testing and everything in between. As I mentioned earlier, the employment provisions in CREMA become effective on August 21st, 2021. I wanted to finish up the marijuana portion of this webinar by highlighting a few court cases regarding marijuana use. First, to summarize a more complex fact pattern, an applicant who lived in Florida was offered and accepted a position in California that was subject to a pre-employment drug test. The employer agreed to a delayed drug test due to the applicant's scheduling conflict. Before the test, the applicant obtained a medical marijuana card, but never disclosed his use of medical marijuana or that he was disabled. During his onboarding in California, he signed a consent form for drug testing, and at that time, he disclosed that he had chronic back pain and provided documentation for his medical marijuana card. He took the drug test and was terminated after testing positive for marijuana. The California court upheld the employer's termination of that employee. First, the plaintiff had not sufficiently proven that he was disabled. Second, the plaintiff's belief that his chronic back pain caused him to be disabled did not establish that he was disabled under the law. specifically because he didn't have any supporting documentation. The court also recognized that employers are allowed to require pre-employment drug testing, including for marijuana. The New Jersey Supreme Court recently decided a case about reimbursement for medical marijuana. Vincent Hager, an employee of M&K Construction, had been injured on the job during his employment with M&K. In order to wean off opioids, Mr. Hager began to use medical marijuana in 2016. He sought reimbursement of his medical marijuana prescription costs from M&K, but it refused. After its review, the New Jersey Supreme Court ordered M&K to reimburse Hager for the prescription costs. It first pointed out that Congress has deprioritized prosecution for the possession of medical marijuana and for marijuana use that is legal under state law. Additionally, the most recent federal appropriations cannot be used to prevent states from implementing medical marijuana laws. Based on this analysis, the court held that the Federal Controlled Substances Act is in essence suspended for the fiscal year and that no conflict exists between federal and state law. There have been other marijuana-related court decisions in 2021, but I'm able to highlight a few cases due to the time constraints. In this final case, a firefighter was terminated after he tested positive for marijuana on a random drug test. He argued that his test results should have been treated as a negative because he is a registered medical marijuana user. The city had terminated his employment, arguing that his marijuana use endangered the health and well-being of others. The employee did not claim that he informed his employer of his medical condition, and while he indicated that he was considering a medical marijuana card, it did not qualify as protected activity under the Americans with Disabilities Act. The District Court of Connecticut dismissed his ADA discrimination claims because marijuana is still illegal under federal law. The court also held that allowing use of marijuana is not a reasonable accommodation because it's illegal under federal law. So the patchwork of marijuana laws and court cases can be confusing and can conflict, especially if an employer operates in more than one state. Best practice is to review the new laws and revisit existing ones with your in-house counsel or outside legal counsel. They can help determine your rights and obligations as an employer. Once you understand what you can and cannot do as an employer, make sure to document. Have policies in place so there's no confusion as to where your company stands. Remember, though, that marijuana is still illegal on the federal level, and keep in mind that you may have accommodation obligations under that state's disability law. You should also work with counsel to determine if you are permitted to drug test and whether there are any limitations on that testing. So what can we expect in the background screening industry and HR in general for the rest of the year? Probably more of the same that we've already been seeing. Ban the box laws and salary history bans are not going anywhere. More jurisdictions are trying to help ex-offenders to get back to work as well. Privacy is still going to be a crucial topic. California is no longer the only state with a privacy law, and other states are probably going to end up following suit in the coming years. It also seems that a new state legalizes marijuana in some way each month, so we probably are going to see more legalization of marijuana at some level. The court should help interpret the law and provide guidance to employers and how they can approach marijuana. AccuSource will keep you posted of any industry trends and hot topics as we learn of them. AccuSource is always happy to provide best practices for your compliance program. First, thoroughly review your background and drug screening procedures as well as hiring practices to ensure that you are compliant with any new laws, and there have been a lot of them this year. Review your employment applications and hiring practices to make sure you're not seeking information about criminal history if you're not allowed to. While you may not be based in a ban-the-box jurisdiction, you should be aware that many jurisdictions do have restrictions. Keep in mind that legislators are starting to require individualized assessments when an employer reviews criminal records and considers taking adverse action. Make sure that your adverse action programs are in compliance with any of these new requirements. Also be aware of any salary history bans that may affect you and update them as needed. Be aware that due to the increase in expungement laws, you may not receive records that you previously did if you rescreen employees. Watch new privacy laws closely. Even if your state doesn't have one now, it may soon. Beware of marijuana legalization and whether you need to adjust your drug screening processes. As always, we recommend reviewing any of these areas with your in-house or outside counsel to determine how the changes affect your background and drug screening programs. We have reached the end of this presentation, and I will now answer the questions that we've received.
Thank you, Jennifer. Now we will dedicate the remainder of the webinar to addressing attendee questions. If you have not had a chance to ask a question via our chat box, please feel free to do so now.
Thanks, Heidi. The first question we have, Jennifer, is some of the new fair chance laws have time-consuming requirements. What do you suggest to make the process easier?
One of the things I always start with when I come across a very complicated process is to write everything down and document everything. Not only is it just a good method to write down an official procedure, which will streamline your process, it also can show that you made a good faith effort to comply with the law in case something does go wrong. Keep in mind, if you're a current AccuSource client, you have the ability to send pre-adverse and adverse action letters through the background screening platform. We have taken all of these different adverse action requirements into consideration when we built out those samples. So for example, if you're in a jurisdiction such as Illinois that requires certain language or an individualized assessment, you can input that information right into the screening system and it will populate with that letter. For some jurisdictions, it's a bit more complicated. New York City, for example, the Fair Chance Act requires a form to be filled out and all kinds of specific information. In that case, you're able to click on it and it'll direct you to print the letter and then either email, fax, or mail it to the person along with the regular letters that you have to send. As always, work with your legal counsel to see how these laws apply with you.
Thank you. The next question we have is, why was there only one salary history ban covered today? Aren't there normally more?
So I get a lot of email updates from different legal blogs and law firms, and didn't really see too many salary history bans this time around. That doesn't mean that there might not have been others, but due to time constraints, we weren't able to cover them anyway. If there are any coming up that we were made aware of, I will likely cover those in either a blog post or in the next webinar at the end of the year.
You had discussed expungement laws. How will those affect our background checks?
So some employers have to rescreen employees, maybe for certain credentialing or access, they have to rescreen them every year, for example. In that case, you may have a background check that previously showed a record, but this time that record's not on there. That could be why. If a record's been expunged, we won't have access to it. The court can no longer provide it. So that could be an example. Or say that you have an applicant who screened with you originally, but for some reason they didn't take the job or you didn't hire them, and then they decide to reapply. You could also run into that issue with rescreening a previous applicant.
All right, we're almost at the end of our time, so this will be our last final live question. So the last question is even more states have legalized marijuana, but is it still illegal at the federal level? Do you have an update on that?
Yes, I do have an update actually. I was looking into this to see what's going on, so that way, in case someone asks us a question about this, I have a general knowledge of it. So last year, the House of Representatives had voted to yes to just decriminalize marijuana, and they did approve it. It did go to the Senate, but it didn't go any farther than that. At this time, legislation is up for review in the House of Representatives. Hasn't gone any further. If we do find out that it's been approved again in the House, if the Senate takes action, or if it ends up legalized, of course, we'll definitely update you via blog post or the webinar.
Thank you, Jennifer, for facilitating this informative webinar, and special thanks to our attendees for joining us today. If you have any additional questions, please contact us at marketing@accusource-online.com.